look, now we change the name. We were talking about temporary residence, and now we talk about temporary stays in Canada. That's the legal term when you don't have a temporary resident permit, but the authorities are not allowed to remove you from Canada for different reasons. Do you understand the difference? One is they issue a visa, you can stay for 6 months, or you can work for a year, or you can do this. No? Fine. This one, you make an application that doesn't allow Immigration Canada or CBSA to remove you back to your country, which technically doesn't provide you with a legal status in Canada, but provide you with an stay. You know, the classic example is refugee claim. When they come and make a refugee application, the government wants to remove them back immediately. But because they make the refugee application, they don't receive a temporary resident permit. What they receive is, okay, the law doesn't allow me to remove you, so I will give you this piece of paper that said that you are a non-status person in Canada. No? You know what I mean? You don't have a status, but I am not able to remove you, so I can give you a piece of paper and you work, or you do different things. You are not technically here. You are not supposed to be here, but I don't know what to do with you. You know what I mean? Because I am not allowed to remove you back to your country, so they give you an stay. So the first example is refugee claimant. The second example is the stay of removal before the federal court. So the federal court, when you lose your refugee application and you apply for federal court for judicial review, the federal court also allow you to stay waiting for the processing time. Sometimes they are going to remove you and you go to the federal court and apply for a stay of removal. Suppose that you are a mother and 3 kids and you have a deportation order, but one of your kids is sick. So, and the Immigration Canada said, no, you gotta go. So you can go to the federal court and say, give me a stay because this happened. And the federal court say, okay, we grant you a stay. They don't grant you a temporary residence or anything. And a stay of the removal. And let me know when everything goes well and we can remove you. So the stay doesn't give you a possibilities for anything else. Sometimes, it is very clear. You know, you can have a date. The federal court can say, you know, I will give you 4 months. Why? Because sometimes you are involved in a legal procedure that doesn't allow you to go, but you have a very concrete date when that procedure is going to finish. So the federal court can say, well, after August 31st, you know, you can go, so why you don't go September 3rd? You know, this kind of stuff happen depending of each case. But my point here is that federal court doesn't grant immigration status in Canada. They only grant a stay of procedures, which imply a physical stay of the person sometimes. Is that okay? The other one is what we call the administrative stay of removal. Sometimes you have a very nice immigration officer and you go and say, you know what? My children haven't finished school. They are going to finish grade 12 in June. So why you don't allow me to stay until they finish, and after graduation I'm leaving with my family. So the Immigration Canada, the CIC can do an admin stay, what is called, and they can grant you. But that is a very subjective kind of decision, because there is not a real process. You ask the petition and they have the power, the jurisdiction to to stay your removal, but has to be for a very specific period of time. They use that one in some, when you get married. When you got married to someone and they are trying to submit a sponsorship application, if you have a nice officer, you can say, you know what, I just got married, I know that I have to go tomorrow, but we are going to submit the papers, could you please? And some guy said, what the heck, so submit the papers and I will wait for you. But the law doesn't say that they must. So it's a very subjective decision, and that's why it's very unfair. Because you have similar cases and they receive totally different decisions. In a small town like this, in a small city like this, there is possible to develop a relationship with the people, and you can use better the administrative state with immigration officers. That's our experience. In Toronto, it's a number, so it's very, very difficult to get there. But if you go to Fort Erie, or if you go to Windsor, or the settlement workers manage to develop relationship, and they can, for humanitarian reason or emotional reasons or whatever, they can stay that one. The court doesn't get involved. The manager of Immigration Canada doesn't get involved. Nobody get involved. It's just, okay, I will give you 2 more weeks or 2 more months, or you know what I mean? Whatever. Is that okay? Yeah. PRA, the pre-removal risk assessment, when I asked the question. This is at the end of the process. You have received a negative decision from the Immigration and Refugee Board. You have received a negative decision from the federal court. You are ready to go. That doesn't give you status. They are saying, apply for PRA, that is a pre-removal risk assessment, and before we make a decision in your case, you are not removable. And then you have the last one, and is a little bit more complicated. In the law, I don't know you are, much old enough to remember that before 2002, there was what we call the Immigration Act, of Canada. That was the name of the law, and was a law for 20 or more years, almost 30 years, since '69. But that changed in June 2002. In the old law, we have something that was called the minister permit. When, in theory, you can go and ask the minister to stay anything and to grant you status. And the minister had the power to do so. You know what I mean? So you make an application for minister permits to stay. An immigration officer can make a decision, but you talk to the minister and say, please. They also use that one for urgent cases of protection. That doesn't give you a status per se. It's the minister saying you can stay, but you have to find another way to become permanent resident. And the law allows you to stay as a permanent resident if you manage to have the temporary resident permit now for 3 years. So, which is at 22. Because Immigration Canada issued the temporary permit now. Not easy, but not that difficult. You can apply and you can obtain. But they know that if they issue it 3 times, they are giving you the possibility to apply for permanent resident. Therefore, the 3rd year is crucial. Or you convince them and they say, okay, because they know that you will become a permanent resident, or they said, no more issues any longer, you gotta go. And it's also, in theory, it's the minister that decide. In the practice, it's a senior immigration officer that make the call. The minister permits, because we're issued in theory by the minister, he was supposed to go every year before Parliament. And he has to report and say, I issued 700 minister permits, and I issue it for these reasons, okay? So that was embarrassing, they said. Because sometimes you issue minister permit against people with criminal record for family reasons. You know, the father of so-and-so and had 3 Canadian child is going to be removed, but this guy had behaved for the last 5 years. So the minister said, okay, what the heck? You know, issue the minister permit and allow this guy to stay and give them a chance. So in order to avoid that embarrassment, they said, well, temporary resident permit is the same, but it's not issued by the minister, will be issued by an officer, and we don't have the minister to go and report to Parliament. Okay, but it's the same thing. The temporary resident permits is a very specialized categories, and they have 3 types of work permits, or of temporary resident permits. One is, let me put an example, for victims of trafficking. If you receive a temporary resident permit for victim of trafficking because you are a victim of trafficking, you don't receive it for a year, you receive it for 6 months, and you are allowed to work. Some other ones, you know, for instance, urgent cases, they receive it for a year, and they are allowed to work. But if you are going to stay here waiting for something else, like a sponsorship application or something, you receive the temporary resident permit for a year, but they don't allow you to work or to receive Medicare. Why? Because in theory, you have a sponsor, no? Yeah. In theory. So, so the temporary resident, you know that every single form in Immigration Canada, they have a code. So if you see a temporary resident permit, and you see the code 10, the person is allowed to work. If they receive the code 9, the person is not allowed to work. So how you change that? By a phone call. You can call the officer and say, you know what, why you don't give 10? Because the law is very flexible in that one. No? They can go and apply because the criteria, but they can do a change. Remember that the immigration officer has a jurisdiction to change a lot of things, you know, just because you convince them or whatever. So it's a very flexible work. It's like, so my suggestion is that you don't fight with the cook. You know what I mean? You are very nice with it. And sometimes the officer make a decision, well, no, let me put it this way. The officer make a mistake and they put a 9 instead of 10 without knowing. We had that situation even in Toronto when you said, why you put a 9? I put a 9? Yes. And what that means? And you started discussion, 9 is don't work, 10 is working, so could you change it? And the person said, okay, send me back the person and I will issue something new. Sometimes you don't have a discussion because they don't accept that they make mistakes. No? But, oh, really? Oh, you know, let me check. Let me talk to my supervisor. That means, oh, maybe I really screwed up about this one. So, and they change it. So, but what you need to know is that not every temporary resident permit is access to work permit. Okay? Not every resident permit, temporary resident permit is receive OHIP. Some of them receive OHIP. The 10, for instance, number 10 receive OHIP. So with the temporary resident permit, you can go and apply. But they don't receive the interim federal health program because they have access to OHIP. And the same rules of the 3 months apply. So you come to Canada and for the first 3 months, you won't have a medical coverage. You know what I mean? So in that case, be flexible.